Energy, and the Department of Defense all continued to refuse to produce a single document or record in response to 71 specific requests, including 5 subpoenas. Additionally, following President Trump's order, 12 current or former administration officials continued to refuse to testify as part of the House's impeachment inquiry. Not only current administration officials, but former administration officials as well. 9 of those witnesses, including senior officials with direct firsthand knowledge of the President's actions, continue to defy subpoenas for testimony because of the President's order. And yet, despite President Trump's obstruction, as you have heard and seen throughout the House manager's presentation of the facts of the President's scheme, the House gathered overwhelming evidence of his misconduct from courageous public servants who were willing to follow the law, comply with subpoenas, and tell the truth. On the basis of that formidable body of evidence, the House adopted the first article of impeachment. These witnesses also testified with great specificity about extensive documents, communications, and records in the possession of the White House and other agencies regarding the President's scheme to coerce Ukraine's leader to help his re-election. As you have heard over the past few days, the House was therefore able to develop an extensive catalog of specific documents and pertinent communication that go to the heart of the President's wrongdoing and which the President has ordered be concealed from Congress and the American people. Revelations of evidence harmful to the President have only continued since the House compiled its investigative reports. Recent court-ordered releases under the Freedom of Information Act, as well as disclosures to the media, have further demonstrated that the White House, OMB, State Department, and other agencies are actively withholding highly relevant documents that could further implicate the President and his subordinates. Over time, these documents and this evidence will undoubtedly come to light, and I ask this body to not wait to read about it in the press or in a book. You should be hearing this evidence now. Hearing this evidence now. Now, there is one point that I would like to make very clear. President Trump's wholesale obstruction of Congress strikes at the very heart of our Constitution and our democratic system of government. The President of the United States could undertake such comprehensive obstruction only because of the exceptional powers entrusted to him by the American people. Only one person in the world has the power to issue an order to the entire executive branch. That person, Senators, as you know, is the President. And President Trump used that power not to faithfully execute the law, but to order agencies and employees of the executive branch to conceal evidence of his misconduct. Now, I know that no other American could seek to obstruct an investigation into his or her wrongdoing in this way. We all know that no other American could use the vast powers of our government to undertake a corrupt scheme to cheat to win an election and then use those same powers to suppress the evidence of his constitutional crime. We would not allow, no, I am convinced that we would not allow any member of our state or local governments to use the official powers of their office to cover up crimes and misdeeds. As this body is well aware, mayors and governors have gone to jail for doing so. Sheriffs and police chiefs are certainly not immune. If we allow President Trump to escape accountability, we will inflict lasting damage on the separation of powers among our branches of government, our fundamental system of checks and balances. It would inflict irreversible damage by allowing this commander-in-chief and establishing precedents for future presidents to act corruptly or abusively and then use the vast powers of their office, the office of the presidency, to conceal their own misconduct from Congress and the American people. In other words, we would create a system that allows this president and any future president to really do whatever he or she wants. It is an attack on congressional oversight, not just on the House, but also on the Senate's own ability to oversee and serve as a check on this and future presidents, both Republican and Democratic administrations. Without meaningful oversight, without the power of impeachment, Americans will have to come to accept a far greater likelihood of misconduct in the Oval Office, and they would not be able to look to other branches of government to hold their president, the people's president, accountable. Executive power without any sort of restraint, without oversight, and without any checks and balances is absolute power. And we know what has been said about absolute power. Absolute power corrupts absolutely. This is the very opposite of what the framers intended. The framers of the Constitution purposefully entrusted the power of impeachment to the legislative branch so that it may protect the American people from a corrupt president. Well, the times, senators, have found us. If Congress allows President Trump's obstruction to stand, it effectively nullifies the impeachment power. Senators, we are the keepers, the protectors, the defenders of what the framers intended. And we must hold any unprincipled and undisciplined executive accountable. Senators, I know that this is not easy. I don't take this moment lightly. These are tough times. I remember quite a few tough times during my 27 years as a law enforcement officer. But we must stop this president. Today, we will explain why. First, we will review key facts regarding the scope and breadth of President Trump's unprecedented actions to stop the House's impeachment inquiry. As you well know, we covered many of these facts on Tuesday when we explained in depth what evidence the president had blocked from Congress. We addressed documents we know the White House and other agencies are concealing and we address testimony the President's aides would provide if they testified under oath. We will therefore review the documents and witnesses briefly. Second, after surveying relevant history and constitutional law, we will explain why obstruction of Congress in and of itself warrants impeachment and removal from office. Finally, we will demonstrate that President Trump is without question guilty of obstruction of Congress, that his defenses lack any legal foundation, and that his actions pose a dire and continuing threat to the foundation of our constitutional framework. This is very simple. It's simple. The President abused the powers entrusted in him by the American people in a scheme to suppress evidence, escape accountability, and orchestrate a massive cover-up. And he did so in plain sight. And his obstruction remains ongoing.
Mr. Chief Justice, Senators, President's Council, before I start, I too want to thank all the senators for being so patient and being such good listeners. It reminds me, quite frankly, of one of the first days that I went to what was affectionately called baby judge school when we first got started. And those are the first two things that they told us, that we needed to be patient, and we needed to listen, and that we needed to be fair.
Mr. Chief
and
Justice.
Always, Senators, President's Council, before I start, I too want to thank all the senators for being so patient and being such good listeners. It reminds me, quite frankly, of one of the first days that I went to what was affectionately called baby judge school when we first got started. And those are the first two things that they told us, that we needed to be patient, and we needed to listen, and that we needed to be fair and always give the opportunity to be heard to each side. And I must say that you have certainly been playing a very good role as judges, because although I know that the press calls you jurors, I know that you are in the role of judges. And I commend you for being good listeners and for having the patience to listen to us this last 2 days and our final remarks today. So thank you all. Now, Ms. Demings has given us an overview of the second article of impeachment, obstruction of Congress. So let us now turn to the facts of the case, because to fully appreciate the scope and the scale of the President's wrongdoing and the size of the cover-up he has orchestrated requires an understanding of the evidence that he has lawlessly hidden from Congress and the American people. President Trump categorically, indiscriminately, and in unprecedented fashion obstructed Congress's impeachment inquiry. In other words, he orchestrated a cover-up. And he did it in plain sight. First, from the beginning, the Trump administration sought to hide the President's misconduct by refusing to turn over the Intelligence Committee whistleblower complaint. That complaint would sound the first alarm of the President's wrongdoing. Second, the President issued an order prohibiting the entire executive branch from participating in the impeachment inquiry. No cooperation, no negotiation, nothing, or as we say in Texas, nada. Following the President's orders, federal agencies refused to produce documents and key witnesses refused to testify. In fact, the President sanctioned specific directions to officials, ordering them to defy congressional subpoenas. Third, and perhaps the most reprehensible of all, the President waged a campaign of intimidation against those brave public servants who did come forward to comply with their obligation under the law. Senators, as I've mentioned, I'm a lawyer and a former judge. I have never, ever seen anything like this from a litigant or a party in any case, not anywhere. But from the very beginning of this scandal, President Trump has sought to hide and cover up key evidence. The cover-up started even before the House began to investigate the President's Ukraine-related activity. It began when the White House sought to conceal the record of Donald Trump's July 25 call with the President of Ukraine by placing it on a highly classified system. But, as we've said before, there was no legitimate national security reason to do so. The cover-up continued. A top OMB official instructed the freeze to be, quoted, closely held. In other words, don't say anything to anybody. Senators, you know, in order to lawfully withhold the funding, the President was required to notify Congress about the amount of money involved and why he was intending to freeze it. Instead, the White House tried to keep the fact of the freeze secret. Maybe they kept it a secret because a senior White House aide, Rob Blair, accurately predicted to his boss, Mick Mulvaney, quote, expect Congress to become unhinged if it learned that bipartisan aid approved for a valuable foreign partner was being frozen for the President's personal gain. But the cover-up reached its peak soon after August 12th, because on August 12th, a whistleblower filed a lawful and protected complaint intended for Congress with the Inspector General of the intelligence community. The President, who was the subject of the complaint, learned of the filing well before Congress and the American people. In an effort to conceal the whistleblower's concerns, the White House and the Department of Justice took an unprecedented step. No administration had ever intervened in such a manner before. But President Trump maneuvered to keep the whistleblower's concerns from the Congressional Intelligence Committees. In the history of the Intelligence Community Whistleblower Protection Act, no credible and urgent complaint had ever been withheld from Congress, not ever before. It was through immense public pressure and vigorous oversight by the House that the Trump administration ultimately produced a complaint to the House and Senate Intelligence Committees. I'll add that even when it was produced, it was weeks after the legal deadline. If the President's efforts to conceal the whistleblower's concerns had succeeded, Congress would never have learned about the existence of the complaint, let alone the allegations that it contained. But this attempt to hide key information from Congress was only the first sign of what was to come. Following new, deeply troubling revelations about the President's July 25 call, on September 24th, the Speaker of the House announced that the House investigations into the President's scheme to pressure Ukraine for personal gain would be folded into the ongoing impeachment inquiry. Just days later, the President began to attack the legitimacy of the House impeachment inquiry. While standing on the tarmac at Andrews Air Force Base, President Trump argued that the House impeachment inquiry, quote, shouldn't be allowed. He claimed that there, and I quote again, there should be a way of stopping it, maybe legally, through the courts. Let's watch the President and what he had to say.
My call was perfect. The President yesterday of Ukraine said there was no pressure put on him whatsoever, none whatsoever. And he said it loud and clear for the press. What these guys are doing, Democrats are doing to this country, is a disgrace, and it shouldn't be allowed. There should be a way of stopping it, maybe legally through the courts.
There should be a way of stopping it. Soon after, President Trump took the matters into his own hands. The President used his authority and his office to wage a relentless and misleading public campaign to attack the impeachment inquiry. The President spent time at rallies, at press conferences, and on Twitter, trying to persuade the American people that the House's inquiry was invalid and fraudulent. Here are just a few of the President Trump's comments about the impeachment inquiry. He called it a witch hunt, a coup, an unconstitutional power grab, a fraud against the American people. He said it's the phony impeachment scam, the phony impeachment hoax, the Ukraine hoax, and a continuation of the greatest scam and witch hunt in the history of our country. And those are probably some of the ones I can repeat here. And it didn't stop. The attacks did not end there. President Trump turned from rhetoric to action. On October 8th, the White House sent a letter to Speaker Nancy Pelosi informing her that President Trump would seek to completely obstruct the impeachment inquiry. They sent this letter, White House stationery. I shouldn't say this, but I'm a lawyer, but very loyally, it's an 8-page letter. You know, lawyers can't do one thing in one page. We got to do 7 or 8. This was 8 pages, and it's long, and no worries, I'm not going to read it all. I just want to get to the bottom line. It says, President Trump cannot permit his administration to participate in this partisan inquiry under the circumstances. He was just saying, we're not going to cooperate. And the letter is dated, again, October 8th, and it's signed by Pat Cipollone, who is here, of course, with us today as the lead counsel for the President. The President did not make any claim of privilege. The President did not make any attempt to compromise. He had no valid excuse. And although we're all too familiar with President Trump's rhetoric and rants, these words in this letter on White House stationery, signed by his lead counsel here today, have consequences. These words had consequences. They were more than just ink on a page. There were more than just 8 pages of words. In the days that followed, President Trump's agencies and officials followed his order to conceal information from Congress. Over the past few days, you've heard in extensive detail from all of us about some of the specific and incriminating documents that the President has withheld from Congress. But again, here's the bottom line. The House investigating committees sought a total of 71 specific categories of documents from 6 different agencies and offices. President Trump blocked every single one of these requests, all of them. Between September 27 and October 10, the investigating committee issued subpoenas to the Department of State, to the White House, the Office of Management and Budget, Department of Defense, and the Department of Energy. The committees always remained open to working with the executive branch to discuss and prioritize the subpoenas. Some agencies initially suggested that they might comply. For example, a few days after receiving the subpoena, the Department of State sent staff and reached out to the committee to, quote, discuss accommodations. As you all know, the accommodation process is when Congress and the executive branch discuss priorities and concerns so that the committee gets what it needs most efficiently while minimizing any burden to the agency. So on October 7th, the committee staff met with State Department officials. During that conversation, the committee made a good faith attempt to engage the department in negotiations. To start, the committees requested that the department prioritize the production of a narrow set of non-privileged documents. The department representatives stated that they would take the request back to senior State Department officials. But that was the end. That was the end. Those priority documents were never provided to the committees. In addition to the State Department, the Department of Defense also showed an initial interest in cooperating. During an October 13 television appearance, Secretary of Defense Mark Esper stated repeatedly that the Department of Defense would seek to comply. He said on air, on TV, that they would seek to comply with the subpoenas. In an exchange on Face the Nation, he was specifically asked, question, very quickly, are you going to comply with a subpoena that the House provided you and provide documents to them regarding the halt to military aid to Ukraine? Answer from the Secretary, yeah, we will do everything we can to cooperate with the Congress. Just in the last week or two, my general counsel sent out a note, as we typically do in these situations, to ensure documents are retained. But again, the question is that a yes? Answer by the Secretary, that's a yes. Question, you will comply with a subpoena? Answer again by the Secretary, we will do everything we can comply. These are his very own words. We can comply. We can comply. But remember that October 8th letter from the White House counsel sent to the Speaker stating that the President's position of total defiance. President Trump, again, I'll quote it, had said, President Trump cannot permit his administration to participate in this partisan inquiry under these circumstances. So every department, every office, top to bottom, of the executive branch was under these instructions. You know, that is about 2 million public servants, top to bottom. The executive branch, all ordered by President Trump not to provide information to Congress. The President offered no accommodation and no opportunity for negotiation. Ultimately, each agency and office followed the President's order. In response to each subpoena, the Trump administration produced no documents, nothing, nada. And the agencies and offices made clear that it was due to the President's instructions. They always deferred to that October 8 letter. For example, despite the Secretary's initial signal of cooperation, I gave you the quote when he was asked specifically on TV. He said they would try to cooperate. But despite that, the Department of Defense later refused to respond to the committee's subpoena. In a letter to the committees, the Department of Defense echoed many of the White House's unsupported legal arguments and concluded, and I quote, "In light of these concerns, and in view of the President's position as expressed in the White House Counsel's October 8th letter, and without waiving any other objections to the subpoena that the Department may have, the Department is unable to comply with your request for documents at this time." Again, on a TV interview on Face the Nation, they tried to ask him again. So when asked by Chris Wallace on Fox News, question, but do you feel Congress has the right to oversight and to be able to see documents from the Pentagon about a program that was approved by Congress? Answer, well, they do, but provided it's done in the right way and proper way. And I think that was the issue. Again, I think my reputation is pretty good in terms of being very transparent. I like to communicate with members of Congress, but in this case, my recollection is that they were technical and legal issues that prohibited us from doing exactly what was requested by Congress. So he said he would try to cooperate, to seek to comply, but now they're backpedaling. But senators, there was no valid technical or legal arguments. None were put forth to justify the stonewalling of the impeachment inquiry. The documents President Trump is withholding are highly relevant, responsive, and would further our understanding of the President's scheme. Here is just a sampling of the documents we know exist that are currently being withheld. National Security Advisor John Bolton's notes, Ambassador Taylor's first-person cable to Secretary Pompeo, emails between OMB and other agencies about the President's directive to place a hold on the Ukraine military aid, and the hundreds of heavily redacted documents that the administration now turned over to third parties under FOIA court orders. Certainly, the documents released pursuant to the FOIA lawsuits were not subject to any claims of privilege or confidentiality or burden. The administration released them publicly. By contrast, the President turned over nothing in response to the House impeachment investigation. Now, senators, there still is another component of the President's obstruction that I want all of us to focus on. Not only did the President block agencies and offices from producing documents, his administration also blocked current and former officials from identifying, producing, or even reviewing relevant documents. First, the Trump administration actively discouraged its employees from even identifying documents responsive to the committee's requests. Deputy Assistant Secretary George Kent testified in his deposition that he informed the State Department attorney about additional responsive records that the department had not collected. According to Kent, the department attorney, quote, got very angry and, quote, objected to Kent raising of the additional information. He, quote, made clear that he did not think it was appropriate for Kent to make the suggestion. So here's a lawyer telling the witness, you know, don't say that. You know, I just, frankly, as again, a lawyer and former judge, I just can't believe something like this would happen. But Kent responded that he was just trying to, quote, make sure that the department was being fully responsive. Second, the Trump administration refused to permit individual witnesses to produce relevant documents themselves. After the State Department failed to respond to voluntary requests for documents at the beginning of the investigation, the committee sent document requests to 6 individual State Department employees. Secretary Pompeo objected to the committee's request to state officials, calling them, quote, it's an act of intimidation and an invitation to violate federal court laws. He also claimed that the House inquiry, quote, an attempt to intimidate, bully, and treat improperly the distinguished professionals of the Department of State. Now, we were the bullies. But let's be clear. His statement has been contradicted by actual State Department professionals from whom the committee sought documents. Kent testified that he, quote, had not felt bullied, threatened, and intimidated by the House. In fact, Kent said that the language in Secretary Pompeo's letter, which had been drafted by a State Department attorney, was without consulting Mr. Kent. He said, quote, it was inaccurate. Inaccurate. Then the State Department ordered witnesses to withhold documents from Congress. For example, on October 14, the department sent a letter to Kent's personal attorney warning, quote, your client is not authorized to disclose to Congress any records relating to official duties. Certain witnesses defied these orders and produced the substance of key documents, providing critical insight into the president's scheme. Other witnesses produced documents to the Trump administration so they could be turned over to Congress. But now the administration is also sitting on those documents and is refusing to turn them over. Ambassador Taylor testified that he turned over documents to the Trump administration, but to his knowledge, they had not been produced to the House. Let's watch.
But has any of the documents that you turned over, to your knowledge, been turned over to the committee?
No.
Well, Senators, I will confirm the committees have not seen not one of these documents, none. Finally, if it could be any worse, well, it is. A Trump administration official, Ambassador Sondland, informed us that he was not even permitted to review his own relevant records in preparation for the testimony. Again, this would be his own records so that he could prepare to testify. So let's watch.
I have not had access to all of my phone records, State Department emails, and many, many other State Department documents. and I was told I could not work with my EU staff to pull together the relevant files and information. Having access to the State Department materials would have been very helpful to me in trying to reconstruct with whom I spoke and met and when and what was said. My lawyers and I have made multiple requests to the State Department and the White House for these materials. Yet these materials were not provided to me, and they have also refused to share these materials with this committee. These documents are not classified, and in fairness, should have been made available.
Of course, we agree. At President Trump's order, agencies and offices refused to produce documents in response to the committee's requests, and they refused to allow individual witnesses to do so either. So let's recap. No documents, zero, goose egg, nada, in response to over 70 requests and 5 subpoenas. No attempt to negotiate. No genuine attempt to accommodate. Categorical, indiscriminate, and unprecedented stonewalling. Again, never in my time as a lawyer or as a judge have I seen this kind of total disrespect and defiance of a lawfully issued subpoena, and all on President Trump's orders. And it could continue because this obstruction of Congress is real and it's beyond comparison. This president should be removed.
Mr. Chief Justice and Senators, let's turn to President Trump's efforts to stop witnesses from testifying. No other president facing impeachment has taken the extreme step to prohibit executive branch witnesses from testifying before Congress. Even President Nixon, who famously attempted to defy a subpoena for tape recordings of his conversations, he let his most senior staff testify before Congress. Now, I remember listening on TV as John Dean testified before the Senate Watergate Committee. He was the president's lawyer. President Nixon didn't block him. Not only did President Nixon allow his staff to testify before Congress, he publicly directed them to testify and without demanding a subpoena. Actually, with the Senate Watergate investigation, President Nixon said, and this is a quote, "All members of the White House staff will appear voluntarily when requested by the committee. They will testify under oath, and they will answer fully all proper questions." Now compare to President Trump. He publicly attacked the House's impeachment inquiry, calling it, quote, "constitutionally invalid." And he ordered every single person working in the executive branch to defy the House impeachment inquiry. As just discussed, in the letter to the Speaker of the House, the White House counsel said that President Trump, quote, "cannot permit his administration to participate." No president ever used the official power of his office to prevent witnesses from giving testimony to Congress in such a blanket and indiscriminate manner. There's no telling how many government officials would have come forward if the president hadn't issued this order. Let's look at some of the witnesses who followed the president's orders. The House issued subpoenas to compel the testimony of 3 officials at the Office of Management and Budget: Acting Director Russell Vought, Associate Director Michael Duffy, and Associate Director Michael McCormick. Now, according to the testimony in the House, which was reinforced by emails recently revealed through the Freedom of Information Act lawsuits, OMB was just central to the President's hold on security assistance to Ukraine. Its officials served as conduits for the White House to implement the hold without directly engaging the agencies that actually supported release of the aid. President Trump directed these three OMB officials to violate their legal obligation by defying lawful subpoenas, and they followed his orders. This isn't just an argument, it's a fact. In response to House subpoenas, the OMB sent a letter to Chairman Schiff refusing to comply, and this is what the letter said. As directed by the White House counsel's October 8, 2019 letter, OMB will not participate in this partisan and unfair impeachment inquiry. In that simple statement, OMB admitted several key points. First, Mr. Cipollini's letter of October 8th was an official directive from the White House. Second, President Trump's blanket order applied to OMB and the three officials subpoenaed by the House. Third, President Trump's blanket order not only directed them to refuse to participate voluntarily, it also directed them to defy House subpoenas. Fourth, President Trump's blanket order directly prevented the three OMB officials from providing testimony to the House. There's no question about the scope of President Trump's order. It was total. There's no question about the intent of the order. It was clearly understood by administration officials as shown by OMB. And there's no question the order had an impact. It directly prevented the House from getting testimony from the three senior officials at OMB. So here we are. The President of the United States issued an official order forbidding every single person who works for the executive branch of our government from giving testimony to the House as part of an impeachment investigation. That order prevented the House from getting testimony from witnesses who knew about the President's conduct. The matter is simple, it's plain to see. The question we here in Congress must ask is whether we're prepared to turn a blind eye to a President's obstruction. Obstruction not only of oversight, but also the power to determine whether Congress may gather evidence in an impeachment proceeding. If the Senate is prepared to accept that, it will mean that not only President Trump, all presidents after him will have veto power over Congress's ability to conduct oversight and the power of impeachment. The House was not prepared to accept that, and that's why the House approved Article 2. As you consider what you think about this, please know that President Trump's blanket order was not the end of his campaign to obstruct the impeachment inquiry. Actually, it was just the beginning. In addition to his total ban of government witnesses, President Trump also sent specific explicit orders. He directed key witnesses to defy subpoenas and to refuse to testify as part of the House's impeachment inquiry. As you know, the House subpoenaed acting White House Chief of Staff Mick Mulvaney. We wanted his testimony. At a White House press briefing in October, I know you've seen it before, Mr. Mulvaney confirmed what we had suspected. Mr. Mulvaney admitted that President Trump withheld the aid to pressure Ukraine into announcing an investigation into the conspiracy theory that Ukraine interfered in the 2016 elections. Here's his words.
Did he also mention to me in the past the corruption related to the DNC server? Absolutely, no question about that. But that's it, and that's why we held up the money.
After this really stunning admission, the House issued a subpoena to require Mr. Mulvaney to testify. But on the day of Mr. Mulvaney's scheduled deposition, the White House sent a letter to his personal attorney. it prohibited from obeying the subpoena. And the letter said, quote, "The President directs Mr. Mulvaney not to appear at the committee's scheduled deposition." When he issued this order, President Trump doubled down on his previous blanket order. He did so after the House voted to approve Resolution 660, which in no uncertain terms made clear that Mr. Mulvaney was being subpoenaed to testify in an impeachment investigation. This order was the first of many. President Trump also ordered another White House official, Robert Blair, not to testify. Mr. Blair is Mr. Mulvaney's senior advisor and his closest aide. He was involved in communications about the hold on Ukraine aid. The day after his initially scheduled deposition, Mr. Blair's personal attorney sent a letter to the House. It said, quote, "Mr. Blair has been directed by the White House not to appear and testify." The House also wanted testimony from John Eisenberg, the senior attorney on President Trump's National Security Council. As you've heard over the past few days, key witnesses, including Dr. Hill, Lieutenant Colonel Vindman, said they were concerned by President Trump's efforts to pressure Ukraine. They were told to report these concerns to Mr. Eisenberg. On the day before his scheduled deposition, the White House sent a letter to Mr. Eisenberg's personal attorney. It said, quote, "The President directs Mr. Eisenberg not to appear at the committee's deposition." Now that language is starting to sound familiar. Mr. Eisenberg's personal attorney then sent a letter to the House. The letter said this: "Under these circumstances, Mr. Eisenberg has no other option that is consistent with his legal and ethical obligations except to follow the direction of his client and employer, the President of the United States. Accordingly, Mr. Eisenberg will not be appearing for a deposition at this time." Now that language I think is important, and it's telling. It shows that President Trump's order left Mr. Eisenberg with, quote, "no other option that is consistent with his legal and ethical obligations." By directing him to defy a lawful subpoena, President Trump created a legal and ethical problem for Mr. Eisenberg. I'm sure you know, contempt of Congress can be punished as a criminal offense. It carries a possible sentence of up to 12 months in jail. No president has ever dared, during an impeachment inquiry, to officially and explicitly order government witnesses to defy House subpoenas. You don't have to consider high-minded constitutional principles to understand why this was wrong. It's simple, really. By ordering specific government officials to defy congressional subpoenas, President Trump forced those officials to choose between submitting to the demands of their boss or break the law. Nobody should abuse a position of power in that way. But President Trump specifically ordered all three of these senior White House officials, Mulvaney, Blair, Eisenberg, to defy the House's subpoenas and refuse to testify. President Trump's efforts to conceal his actions didn't stop there, and they didn't stop at the front door of the White House. No less than 12 other witnesses were specifically ordered not to testify. One of those witnesses, Ulrich Breckbull, hasn't been highlighted much over the past few days, but the way he fits into the story is worth noting. Mr. Breckbull is a senior official at the State Department. Like these other senior officials, he was ordered not to testify. In a letter to the House, his attorney said, quote, "Mr. Breckbull has received a letter of instruction from the State Department directing that he not appear." Mr. Breckbull is still another person who could shed light on President Trump's actions. He was kept updated on Rudy Giuliani's broader efforts in Ukraine. He had firsthand knowledge of Secretary Pompeo's involvement. For one thing, he handled Ambassador Yovanovitch's recall from Ukraine, though he refused to meet with her in the aftermath. Also, messages by Ambassador Volker show that Mr. Breckbull knew about Mr. Giuliani's efforts in the Ukraine as they occurred. On July 10th Ambassadors Taylor, Volker, and Sondland discussed Rudy Giuliani's push abroad. While discussing the problems Rudy was creating by meddling in official U.S. foreign policy, Ambassador Taylor noted that he, quote, briefed Ulrich this afternoon. Also on August 11th, Ambassador Sondland emailed Mr. Breckbull to ask him to brief Secretary Pompeo on a statement he was negotiating with President Zelensky, the aim of, quote, making the boss happy enough to authorize an invitation. Ambassador Sondland wrote to him, quote, Kurt and I negotiated a statement from Z to be delivered for our review in a day or two. The contents will hopefully make the boss happy enough to authorize an invitation. Now, State Department Executive Secretary Lisa Kenna answered Ambassador Sondland several hours later, letting him know that she'd pass that information on to Secretary Pompeo. Let's consider and pause here why this message to Mr. Breckbull, which the State Department continues to conceal, is important. In this exchange, Ambassador Sondland told Breckbull that he had negotiated a deal to get President Zelensky to make a statement, and that Sondland hoped that the promised statement would, quote, make the boss happy enough to authorize an invitation. It shows that senior State Department leadership, including Secretary Pompeo, were quite aware of the deal to trade an invitation to the White House for a statement from President Zelensky. Indeed, Ambassador Sondland confirmed that he kept them in the loop. Here's his testimony.
We kept the leadership of the State Department and the NSC informed of our activities, and that included communications with Secretary of State Pompeo, his counselor, Ulrich Breckbull, his executive secretary, Lisa Kenna, and also communications with Ambassador Bolton, Dr. Hill, Mr. Morrison, and their staff at the NSC. They knew what we were doing and why.
8 other witnesses were also ordered not to testify as part of the House's impeachment inquiry. But those 8 witnesses came forward anyway, despite the President's efforts to prevent them from testifying. All of the following witnesses were told not to testify: Ambassador Marie Yovanovitch, Ambassador Gordon Sondland, Deputy Assistant Secretary of State George Kent, Ambassador Bill Taylor, Deputy Assistant Secretary of Defense Laura Cooper, Deputy Associate Director at OMB Mark Sandy, State Department official Catherine Croft, and State Department official Christopher Anderson. Each of these 8 witnesses followed the law. They obeyed House subpoenas, and they testified before the House. In all, we know that by issuing the blanket order and later specific orders, President Trump prevented at least 12 current or former administration officials from testifying during the House's impeachment inquiry. He specifically forced 9 of those witnesses to defy duly authorized subpoenas. The facts are straightforward and they're not in dispute. First, in the history of our republic, no president ever dared to issue an order to prevent even a single government witness from testifying in an impeachment inquiry. Second, President Trump abused the power of his office by using his official power in an attempt to prevent every single person who works in the executive branch from testifying before the House. Finally, President Trump's orders, in fact, prevented the House from obtaining key witness testimony from at least 12 current or former government officials. President Trump's orders were clear. They were categorical, they were indiscriminate, and they were wrong. They prevented key government witnesses from testifying. There's no doubt. That's obstruction, plain and simple.
Now let us turn to some final set of facts. In a further effort to silence his administration, President Trump engaged in a brazen effort to publicly attack and intimidate the dedicated public servants who came forward to testify. To be clear, these witnesses didn't seek the spotlight in this way. For years, they had quietly and effectively performed their duties on behalf of our national interest and on behalf of the American people. Why would they seek the spotlight in this way, knowing that the President of the United States would lead the chorus of attacks against them? And he did. In response, the President issued threats, openly discussed possible retaliation, attacked their character and patriotism, and subjected them to mockery and other insults. The President's attacks were broadcast to millions of Americans, including the witnesses, their families, their friends, and their co-workers. This campaign of intimidation risks discouraging witnesses from coming forward voluntarily or complying with mandatory subpoenas for documents and testimonies. And as we all know, witness intimidation is a federal crime. There is simply not enough time today to walk through each of the President's attacks on the House's witnesses. But let's talk about a few. As I am sure my colleagues recall, the House subpoenaed Ambassador Marie Yovanovitch for public testimony. Ambassador Yovanovitch's first tour was in Somalia, an increasingly dangerous place as that country's civil war progressed. During a different tour, when Ambassador Yovanovitch helped to open a U.S. embassy, during which time the embassy was attacked by a gunman who sprayed the embassy building with gunfire. Ambassador Yovanovitch has also served as ambassador to Armenia and served the U.S. Embassy in Moscow. As Chairman Schiff said earlier, she has served in some dangerous places around the world on behalf of our interests and the interests of the American people. President Trump's Undersecretary of State for Political Affairs described Ambassador Yovanovitch as, and I quote, an exceptional officer doing exceptional work at a critical embassy in Kyiv. But during Ambassador Yovanovitch's public testimony, President Trump tweeted, "Everywhere Marie Yovanovitch went turned bad." She started off in Somalia. How did that go? Then fast forward to Ukraine, where the new Ukrainian president spoke unfavorably about her in my second phone call with him. It is the U.S. president's outright or absolute right to appoint ambassadors. In that same hearing, Chairman Schiff asked Ambassador Yovanovitch for her reactions to the president's attacks during her testimony before the House. Let's listen to that exchange.
Ambassador, you've shown the courage to come forward today and testify. Notwithstanding the fact you were urged by the White House or State Department not to, notwithstanding the fact that, as you testified earlier, the president implicitly threatened you in that call record, and now the president in real time is attacking you. What effect do you think that has on other witnesses' willingness to come forward and expose wrongdoing?
Well, it's very intimidating.
It's designed to intimidate, is it not?
I mean, I can't speak to what the president is trying to do, but I think the effect is to be intimidating.
Well, I want to let you know, Ambassador, that some of us here take witness intimidation very, very seriously.
The House also subpoenaed the public testimony of Ambassador William B. Taylor, another career public servant who graduated at the top of his class from West Point, served as an infantry commander in Vietnam, and earned a Bronze Star and an Air Medal with the V device for valor. Yes, yet shortly after Ambassador Taylor came forward to Congress, President Trump publicly referred to him as a never-Trumper without any basis. And then, when a reporter noted that Secretary of State Mike Pompeo had hired Ambassador Taylor, President Trump responded, and I quote, "Hey, everybody makes mistakes." He then had the following exchange about Ambassador Taylor. Let's listen.
Do you want him out now?
He's a never-Trumper. His lawyer's the head of the never-Trumpers. They're a dying breed, but they're still there.
Ambassador Taylor has since stepped down from his position as our chief diplomat in Ukraine. In addition to his relentless attack on witnesses who testified in connection to the House's impeachment inquiry, the president also repeatedly threatened and attacked the member of the intelligence community who filed the anonymous whistleblower complaint. In more than 100 statements about the whistleblower over a period of just 2 months, the president publicly questioned the whistleblower's motives and disputed the accuracy of the whistleblower's account. But most disturbing, President Trump issued a threat against the whistleblower and those who provided information to the whistleblower. Let's listen.
I want to know who's the person that gave the whistleblower, who's the person that gave the whistleblower the information? Because that's close to a spy. You know what we used to do in the old days when we were smart, right? With spies and treason, right? We used to handle it a little differently than we do now.
The president's need to conceal his actions was so extreme that he even attacked the credibility of those witnesses who served our country in combat. This included active duty military personnel and veterans who earned the Purple Heart and Bronze Star, among other battlefield recognition. But President Trump showed utter disregard for such patriotism. For example, President Trump attacked Lieutenant Colonel Vindman during his testimony on November 19th, seeking to question his loyalty to the United States. The president retweeted, Lieutenant Colonel Vindman was offered the position of defense minister for the Ukrainian government 3 times. Lieutenant Colonel Vindman, the National Security Director for Ukraine, has been an active duty Army officer for more than 20 years. Lieutenant Colonel Vindman earned a Purple Heart for wounds he sustained in an improvised explosive attack or device in Iraq. President Trump's campaign of witness intimidation is reprehensible, debases the presidency, and was part of his effort to obstruct the impeachment inquiry. The fact that it is the President of the United States making these threats tells us something. It tells us that the President desperately wanted to keep witnesses from testifying and thus further obstruct Congress's inquiry. Senators, we cannot and we must not condone President Trump's attacks on whistleblowers and witnesses, people who truly have the ability to put our country first.
Now that we have carefully reviewed the facts and have described the President's categorical obstruction of Congress, we address questions of law. This discussion need not be abstract. The President's obstruction impacts the Senate directly. It impacts the constituents you represent. It impacts you, because your job as a member of Congress is to hold the executive branch in check. This is true no matter who occupies the White House or which party controls the House or Senate. And the further the President, any President, departs from the law and the Constitution, the more important it is for you to do your job. I suspect that there is common ground here. We all know that in order for Congress to do its work, we must have information. What is reasonable policy? What is the administration doing? Do we support it? Should we oppose it? Should we enact legislation to correct the problem? Asking questions, gathering information, making decisions based on the answers, this is one of the fundamental functions of Congress. I suspect that we agree on this as well. Our ability to do that work depends on our gathering information. It depends on the power of the congressional subpoena. Even when you make a polite request for information from a friendly administration, that request is backed by the threat of a subpoena. And although the power of the congressional subpoena has been affirmed repeatedly by the courts, enshrined in the rules of the House and Senate, and respected by executive branch agencies for centuries, if the President chooses to ignore our subpoenas, our power as a branch of government, our ability to do our jobs, our ability to keep an administration in check, our ability to make sure that the American people are represented by a Congress and not just by a President, is diminished. Please know that we are not talking about a disagreement over the last few documents at the end of a long production schedule. We are talking about a direct order from the President of the United States to completely disregard all our subpoenas, to deny us all information the President wants to keep secret. This is in order to deprive Congress of our ability to hold an administration accountable. It is a bid to neuter Congress, to render the President all-powerful, since Congress could not have any information the President didn't want us to have. Without information, we cannot act. And so we must ask, is there a consequence for a President who defies our subpoenas absolutely, who says to all branches of the administration, do not obey a single congressional subpoena, categorically, without knowing the subject of the subpoena? Just never answer a congressional subpoena? Who denies Congress the right to any information necessary to challenge his power? Would Madison, Hamilton, and Washington support removing a President who declares that the Constitution lets him do whatever he wants, and who brazenly adds that he can ignore any effort to investigate, even when backed by subpoenas that the law requires him to obey? The answer to all these questions is a resounding yes. But before diving in, I'd like to set the historical scene. The framers were wise, and so they worried that presidents would abuse their power for personal gain. They feared that someday a president might mistake himself for a king, whose decisions cannot be questioned, whose conduct cannot be investigated, whose power transcends the rule of law. Such a would-be king would certainly think things like, quote, I have the right to do whatever I want as president. He might believe that it is, quote, illegitimate for anyone to investigate him. Of course, not even the framers could have imagined that a president would say these things out loud. A president with this view of raw power would attack anyone who tried to hold him to account, branding them, quote, human scum, and, quote, the enemy of the people. He would argue that courts have no power to enforce subpoenas against him. He would conscript his allies to ridicule Congress. He would harass witnesses who testified against him, declaring it disloyal to question his conduct. He would use the powers of his eye office to sabotage our system of checks and balances. All of this we have seen in the last few years, indeed in the last few months. The framers wrote the impeachment clause to protect the American people from such a president. The impeachment clause exists to protect our freedom and our democracy in between elections. It exists to remind presidents that they serve the public, not the other way around. It is a reminder to presidents that they answer to something greater than themselves. It confirms that nobody in America is above the law, not even the president. But as we have discussed, the impeachment power does not magically protect us when the president commits high crimes and misdemeanors. In Benjamin Franklin's words, the framers left us a republic, if we can keep it. Now, one way we can uphold that promise is to do our duty as elected members of Congress to hold the executive branch in check. That responsibility is part of the constitutional design. The burden is ours, regardless of our political party, no matter who sits in the Oval Office. In the ordinary course, when we do our jobs, we do our nation a service by holding the executive branch, both its political leadership and its professional core, accountable to the people for its actions. And when the President's conduct exceeds the usual constitutional safeguards, it falls on the House to investigate presidential wrongdoing and, if necessary, to approve articles of impeachment. It then falls on the Senate to judge, convict, and remove presidents who threaten the Constitution. This entire framework depends on Congress' ability to discover and then to thoroughly investigate presidential malfeasance. If presidents could abuse their power and then conceal all the evidence from Congress, the impeachment clause would be a nullity. We, the people, would lose a vital protection. That is why officials throughout history have repeatedly recognized that subpoenas served in an impeachment inquiry must be obeyed, including by the President. It is why, before President Trump, only a single official in American history has ever defied an impeachment subpoena. And that is why that official, Richard Nixon, faced an article of impeachment for doing so. As the House Judiciary Committee reasoned in its analysis of Nixon's obstruction, quote, unless the defiance of the House subpoenas is considered grounds for impeachment, it is difficult to conceive of any president acknowledging that he is obligated to supply the relevant evidence necessary for Congress to exercise its constitutional responsibility in an impeachment proceeding. Representative Robert McClory, a Republican from Illinois, explained the importance of this article of impeachment for our separation of powers. He said, if we refuse to recommend that the President should be impeached because of his defiance of the Congress with respect to the subpoenas that we have issued, the future respondents will be in the position where they can determine themselves what they are going to provide in an impeachment inquiry and what they are not going to provide. And this would be particularly so in the case of an inquiry directed toward the President of the United States. So it not only affects this president, but future presidents. And that's where we find ourselves now, but with even greater force. President Nixon authorized other executive branch officials and agencies to honor their legal obligations. He also turned over many of his own documents. President Trump, in contrast, directed his entire administration, every agency, every office, and every official not to cooperate with the impeachment inquiry. As in Nixon's case, President Trump's obstruction is merely an extension of his cover-up. As in Nixon's case, President Trump's obstruction reveals consciousness of guilt. Innocent people do not act this way. They do not hide all the evidence. And like Nixon, President Trump has offered an assortment of arguments to excuse his obstruction. But as was true in Nixon's case, none of these excuses can succeed. At bottom, these arguments amount to a claim that the President can dictate the terms of his own impeachment inquiry. President Trump's lawyers may insist that his grounds for defying Congress are unique and limited, that they only apply here, just this one time, that it was the House, not the President, that broke from precedent, that he would gladly comply with subpoenas if only the House would do as he insists. That is pure fantasy. The President's arguments are not a one-ride ticket. They're not unique to these facts. Unless they are firmly and finally rejected here, these bogus excuses will reappear every time Congress investigates any president for serious abuses of power. Every single time. They will constitute a playbook for ignoring oversight available to all future presidents, Democratic or Republican. These arguments are not consistent with the Constitution. They are loyally window dressing for an unprecedented, dangerous power grab. Plenty of presidents and judges have complained about impeachment inquiries, declaring their own innocence, attacking the House's motives, and insisting that due process entitled them to all sorts of things. But no president or judge, except Richard Nixon, has ever defied subpoenas on that basis. And no president or judge, none, has ever directed others to defy subpoenas categorically across the board. They have all eventually recognized their obligations under the law. President Trump stands alone. And if President Trump is permitted to defy our subpoenas here in an impeachment inquiry, when the courts have said the congressional power of inquiry is at its highest, imagine what future presidents will do when we attempt to conduct routine oversight. President Trump is the first leader of this nation to declare that nobody can investigate him for official misconduct except on his own terms. In word and in deed, President Trump has declared himself above the law. He has done so because he is guilty and wishes to conceal as much of the evidence from the American people and from this body as he can. In that, he must not succeed. If President Trump is allowed to remain in office after this conduct, historians will mark the date that this Senate allowed this president to break one of our mightiest defenses against tyranny. They will wonder why Congress so readily surrendered one of its core constitutional powers. They will wonder why Congress admitted that a president can get away with anything, can violate any constitutional rule, any liberty, any request for information, and get away with it simply by saying, I don't have to answer your questions. Congress has no power to make me answer questions about my conduct. That's what is at stake. And future people will despair that future presidents can abuse their power without fear of consequence or constraint. Let's begin with a legal premise of the second article of impeachment. Congress has the power to investigate presidents for official misconduct. This premise is indisputable. Article 1 of the Constitution, all legislative powers herein granted shall be vested in the Congress of the United States, which shall consist of a Senate and House of Representatives. Each House may determine the rules of its own proceedings. Our investigations are grounded in Article 1 of the Constitution, which grants Congress all legislative powers and authorizes each House to determine its own rules. As the Supreme Court has explained, the Constitution thus vests the House and the Senate with a power of inquiry that is, and I quote, penetrating and far-reaching, close quote. Moreover, Congress can effectuate that power of inquiry by issuing subpoenas commanding the recipient to provide documents or to testify under oath. Compliance with subpoenas is mandatory. It's not at the option of the executive or the president. As the Supreme Court has explained, quote, it is unquestionably the duty of all citizens to cooperate with the Congress in its efforts to obtain the facts needed for intelligent legislative action. It is their unremitting obligation to respond to subpoenas, to respect the dignity of the Congress and its committees, and to testify with respect to matters within the province of proper investigation. More recently, United States District Judge Ketanji Brown Jackson has elaborated, quote, blatant defiance of Congress' centuries-old power to compel the performance of witnesses is not an abstract injury, nor is it a mere banal insult to our democracy. It is an affront to the mechanism for curbing abuses of power that the framers carefully crafted for our protection, and thereby recalcitrant witnesses actually undermine the broader interests of the people of the United States. In recognition of the important role that congressional inquiries play in protecting our democracy and in guarding the American people, it is unlawful to obstruct them. Of course, while Congress investigates many issues, one of the most important is misconduct in the executive branch. There is a long history of congressional investigations into the executive branch. To name a few especially famous cases, Congress has investigated claims that President Lincoln mishandled Civil War military strategy, the infamous Teapot Dome scandal under President Harding, President Nixon's involvement in the Watergate scandal, President Reagan's involvement in the Iran-Contra affair, President Clinton's real estate dealings in the Monica Lewinsky scandal, warrantless wiretapping under President George Bush, attacks on American personnel in Benghazi under President Obama. Since the dawn of the Republic, presidents have recognized Congress's power to investigate the executive branch. Even in sensitive investigations involving national security and foreign policy, presidents have provided Congress with access to senior officials and important documents. For example, in the Iran-Contra inquiry, President Reagan's former National Security Advisor, Oliver North, and the former Assistant to the President for National Security Affairs, John Poindexter, testified before Congress. President Reagan also produced relevant excerpts of his personal diaries to Congress. During the Clinton administration, Congress obtained testimony from top advisors, including the President's Chief of Staff, Matt McLarty, his Chief of Staff, Erskine Bowles, White House Counsel Bernie Nussbaum, and White House Counsel Jack Quinn. In the Benghazi investigation, President Obama made many of his top aides available for transcribed interviews, including National Security Advisor Susan Rice and Deputy National Security Advisor for Strategic Communications, Benjamin Rhodes. The Obama administration, in that case, also produced more than 75,000 pages of documents, including 1,450 pages of White House emails with communications of senior officials on the National Security Council. To be sure, certain House Republicans complained loudly that the Obama administration's response to the Benghazi investigation was insufficient. Just imagine how they would have reacted if President Obama had ordered total defiance of all subpoenas. There would have been outrage. Why? Because Congress unquestionably has the authority to investigate presidential conduct. Now, not only does Congress have the power to investigate the executive, but as we have discussed, Article 1 of the Constitution gives the House the sole power of impeachment. The framers intended this power to be an essential check on out-of-control presidents. But it does not work automatically. The House must investigate, question witnesses, and review documents. Only then can it decide whether to approve or not approve articles of impeachment. Therefore, when the House determines that the President may have committed high crimes and misdemeanors, it has the constitutional duty to investigate his conduct. In such cases, the House acts not only pursuant to its ordinary legislative authority, but also serves as a grand inquest of the nation. Because an impeachment inquiry wields one of the greatest powers in the Constitution, a power that exists specifically to constrain presidents, its subpoenas are backed with the full force of the impeachment clause. They cannot be thwarted by ordinary executive privileges or ordinary objections. It is therefore presumed, as President Polk conceded over 150 years ago, that, quote, all the archives and papers of the executive departments, public or private, would be subject to inspection, and, quote, every facility in the power of the executive would be afforded to enable the House to prosecute the investigation. What investigation? The impeachment investigation of President Polk. President Polk's statement, which we will return to, was no outlier. Presidents have long understood that they must comply with impeachment inquiries. Consistent with this understanding, in the history of the Republic, no president has ever claimed the unilateral prerogative to categorically defy a House impeachment inquiry. On the contrary, every president facing this issue has agreed that Congress possesses a broad and penetrating power of inquiry when investigating grounds for impeachment. This directly refutes President Trump's claim that he obstructed Congress to protect the office of the President. Every prior occupant of his office has disavowed the limitless power that he asserts. That matters. As the Supreme Court explained just a few years ago, and I quote, "Long settled and established practice is a consideration of great weight in a proper interpretation of constitutional provisions regulating the relationship between Congress and the President." So let's take a quick tour of the historical record. To begin at the beginning, a sweltering summer in Philadelphia, 1787, the framers discussed at length the balance between presidents and Congress. Remember, they had just fought a bloody war to rid themselves of a tyrant. And they were very conscious they didn't want another tyrant. When impeachment came up, they agreed it would limit the president's authority. But a strong majority of framers saw that as a virtue, not a vice. They wanted to empower the president, but also to keep his power from getting out of hand. Yet impeachment could not serve that role if the House were unable to investigate the president for suspected high crimes and misdemeanors. This was recognized early on, starting with our very first president. In 1796, the House requested that President Washington provide it with sensitive diplomatic materials relating to the hugely unpopular Jay Treaty with Great Britain. President Washington declined, since this request intruded upon his executive functions. But Washington agreed that impeachment would change his calculus. In the ensuing debates, it was noted on the House floor that Washington had admitted, quote, that where the House expresses an intention to impeach, the right to demand from the executive all papers and information in his possession belongs to it. All papers and information. This was only the first of many references to that point in our constitutional tradition. For example, less than 40 years later, in 1833, Justice Joseph Story remarked upon the dangers of presidential obstruction. He wrote, "The power of impeachment will generally be applied to persons holding high offices under the government, and it is of great consequence that the President should not have the power of preventing a thorough investigation of their own conduct." Consistent with this teaching, President Polk later offered his clear and insightful explanation of why presidents must honor all impeachment subpoenas. As I mentioned just a moment ago, he said, and I quote, "It may be alleged that the power of impeachment belongs to the House of Representatives, and that with a view to the exercise of this power, that House has the right to investigate the conduct of all public officers under the government." This is cheerfully admitted. Decades later, during our first presidential impeachment inquiry, President Andrew Johnson recognized Congress's power to thoroughly investigate him and his executive branch subordinates. In 1867, for example, the House Judiciary Committee obtained executive and presidential records. The committee interviewed cabinet officers and presidential aides about cabinet meetings and private conversations with the president by his top aides and cabinet officials. And multiple witnesses, moreover, answered questions about the opinions of the president, statements made by the president, and advice given to the president. There is no evidence that Johnson ever asserted any privilege to prevent disclosure of presidential conversations to the committee, or failed to comply with any of the committee's requests. Thus, in the first 80 years of the Republic, Presidents Washington, Polk, and Johnson, along with members and committees of the House and a Supreme Court justice, all recognize that Congress is authorized by the Constitution to investigate for impeachment, and that presidents are obligated to give all information requested. President Trump's attempt to stonewall Congress would have shocked those presidents. With only a few exceptions, invocations of the impeachment power subsided from 1868 to 1972. Yet even in that period, while objecting to ordinary legislative oversight, Presidents Ulysses Grant, Grover Cleveland, and Theodore Roosevelt each noted that Congress could obtain key executive branch documents in an impeachment inquiry. They thus confirmed yet again that impeachment is different. Under the Constitution, it requires full compliance. Then came Watergate, when President Nixon abused the powers of his office to undermine his political opponents. But even Nixon understood that he must comply with subpoenas for information relating to his misconduct. Thus, he stated in March 1973 regarding the Senate's Watergate investigation, I quote, "All members of the White House staff will appear voluntarily when requested by the committee. They will testify under oath and they will answer fully all questions." As a result, many senior White House officials testified, including White House counsel John Dean, White House Chief of Staff H.R. Haldeman, and Deputy Assistant to the President Alexander Butterfield. In addition, Nixon produced many documents in response to congressional subpoenas, including notes from meetings with the President. As the House Judiciary Committee explained at the time, 69 officials had been subjected to impeachment investigations throughout American history. Yet, and I quote, "With the possible exception of one minor official who invoked the privilege against self-incrimination, not one of them challenged the power of the committee conducting the investigation to compel the production of evidence it deemed necessary." President Nixon's production of records was incomplete, however, in a very important respect. He did not produce tape recordings of key Oval Office conversations. In response, the House Judiciary Committee approved an article of impeachment against the President for obstruction of Congress. 24 years later, the House undertook impeachment proceedings against President Clinton. Consistent with President and entirely unlike President Trump, Clinton pledged to cooperate fully with the impeachment investigations. Ultimately, he provided written responses to 81 interrogatories from the Judiciary Committee, and 3 witnesses provided testimony during the Senate trial. As this review of the historical record proves, presidents have long recognized that the Constitution compels them to honor subpoenas served by the House in an impeachment inquiry. Stated simply, President Trump's categorical blockade of the House, his refusal to honor any subpoenas, his order that all subpoenas, without even knowing what they were, all subpoenas be defied, has no analog in the history of the Republic. Nothing even comes close. He has engaged in obstruction that several of his predecessors have expressly said is forbidden, and that led to an article of impeachment against Nixon. President Trump is an outlier. He is the first and only president ever to declare himself unaccountable and to ignore subpoenas backed by the Constitution's impeachment power. If he is not removed from office, if he is permitted to defy the Congress entirely, categorically, to say that subpoenas from Congress in an impeachment inquiry are nonsense, then we will have lost, the House will have lost, the Senate certainly will have lost all power to hold any president accountable. This is a determination by President Trump that he wants to be all-powerful. He does not have to respect the Congress. He does not have to respect the representatives of the people. Only his will goes. He is a dictator. This must not stand, and that is why, another reason, he must be removed from office.
Mr. Chief Justice, Senators, we've now shown how the extreme measures President Trump took to conceal evidence and block witnesses defies the Constitution and centuries of historical practice. But there's more to this story, and it only further undermines President Trump's case. The position he's taken is not only baseless as a historical matter, it's also inconsistent with the Justice Department's stated reason for refusing to indict or prosecute presidents. Now, the Department of Justice's unwillingness to indict a sitting president creates a danger that the president can't be held accountable by anyone, even for grave misconduct. To its credit, the Department of Justice recognized that risk. In its view, quote, "The constitutionally specified impeachment process ensures that the immunity would not place the president above the law." This argument by the Justice Department is really important. In justifying its view that a president can't be held criminally liable while in office, DOJ relies on Congress's ability to impeach and remove a president. But the Justice Department's rationale, it falls apart if the constitutionally specified impeachment process can't function because the president himself has obstructed it. The Supreme Court correctly noted in Nixon versus Fitzgerald, and that's not Richard Nixon, it's Judge Nixon, that vigilant oversight by Congress is necessary to, quote, make credible the threat of impeachment. The president should not be treated as immune for criminal liability because he's subject to impeachment, but then be allowed to sabotage the impeachment process itself. That's what this president did. That places him dangerously above the law and beyond the separation of powers. Presidents can't be above the law. Presidents, like everyone else, must obey subpoenas served in an impeachment inquiry. In 1880, the Supreme Court explained, quote, where the question of such impeachment is before either House of Congress, acting in its appropriate sphere on that subject, we see no reason to doubt the right to compel the attendance of witnesses and their answer to proper questions in the same manner and by the use of the same means that courts of justice can in like cases. Almost a century later, Judge John Sirica's influential opinion on the Watergate roadmap in 1974 emphasized the special weight assigned to Congress in an impeachment. He wrote, "It should not be forgotten that we deal in a matter of the most critical moment to the nation, an impeachment investigation involving the President of the United States. It would be difficult to conceive of a more compelling need than that of this country for an unswervingly fair inquiry based on all the pertinent information." That same year, the Supreme Court decided the famous case of Nixon versus the United States. That's President Nixon. I was standing just across the street from the court when the case was handed down. And I remember seeing the reporters running down those marble steps, clutching the court's unanimous decision. The decision forced the release of key Oval Office tapes that President Nixon had tried to cover up by invoking executive privilege. In short order, it led to the resignation of President Nixon. The plaintiff in that case was actually the special prosecutor, Leon Jaworski, who had been appointed to investigate the Watergate burglary and who had issued subpoenas for the Nixon tapes. The Supreme Court upheld these subpoenas against President Nixon's claim of executive privilege. It reasoned that his asserted interest in confidentiality could not overcome the constitutionally grounded interest in the fair administration of criminal justice. Now, in reaching that conclusion, the court said this, quote, "The ends of criminal justice would be defeated if judgments were to be founded on a partial or speculative presentation of the facts. The very integrity of the judicial system and public confidence in the system depend on full disclosure of all facts within the framework of the rules of evidence." That reason, which was a unanimous decision by the Supreme Court in the Nixon tapes case, applies with full force, indeed greater force, to impeachments. The House Judiciary Committee recognized that when it approved an article of impeachment against President Nixon for obstruction of Congress. It reasoned as follows, quote, "If a generalized presidential interest in confidentiality cannot prevail over, quote, the fundamental demand of due process of law in the fair administration of justice, then neither can it be permitted to prevail over the fundamental need to obtain all the relevant facts in the impeachment process." whatever the limits of legislative power in other contexts, and whatever need may otherwise exist for preserving the confidentiality of presidential conversations, in the context of an impeachment proceeding, the balance was struck in the favor of the power of inquiry. Accordingly, President Trump's conduct is unprecedented and actually offensive to the precedents, and it is inconsistent with his duty, his oath, to faithfully execute the laws. Now, that obligation to see that the laws are faithfully executed is not just about enforcing statutes. It's a duty to be faithful to the Constitution, every part of it, as stated in the text and understood across history, and it is a duty he has violated by obstructing Congress here. I want to make one additional point regarding the judiciary. Now, presidents have an obligation to comply with the Congress's impeachment inquiry, regardless of whether a court has reviewed the request. We make this point even though I think President Trump's lawyers would be making a mistake to raise it. After all, the president's lawyers can't have it both ways. They can't argue here that we must go to court and then argue in court that our case can't be heard. Anyway, the House's sole power of impeachment wouldn't be sole or much of a power if the House could not investigate the president at all without spending years litigating before the third branch of government. It would frustrate the Constitution for the House to depend entirely on the judiciary to advance its impeachment-related investigatory powers. Consistent with this understanding, before President Trump, the House had never before filed a lawsuit to require testimony or documents in a presidential impeachment. We didn't have to. No president ever issued a blanket ban on compliance with House subpoenas or challenged the House to find a way around his unlawful order. In this strange and unprecedented situation, it's appropriate for Congress to reach its own judgment that the president is obstructing the exercise of its constitutional power. As then Representative Lindsey Graham explained in 1998 during the Clinton proceedings where we served together on the Judiciary Committee, quote, "The day Richard Nixon failed to answer that subpoena is the day he was subject to impeachment because he took the power from Congress over the impeachment process away from Congress, and he became the judge and jury." There's still another reason why it would be wrong and dangerous to insist that the House cannot take action without involving the courts, and that reason is delay. Consider just 3 lawsuits filed by House committees over the past 2 decades to enforce subpoenas against senior executive branch officials. Now, I served on the Judiciary Committee when we decided that we needed to hear from former White House counsel Harriet Miers. In Committee on the Judiciary versus Miers, the Judiciary Committee tried to enforce a subpoena that required her to give testimony about the contentious firing of 9 U.S. attorneys. The committee served the subpoena in 2007. We negotiated, as courts indicate you should, with the White House, and we finally filed suit in March of 2008. We won a favorable district court order in July 2008, but we didn't receive testimony from Miers until June of 2009. That was 2 years. In Committee on Oversight and Reform versus Holder, the Committee on Oversight and Reform tried to force Attorney General Eric Holder to produce additional documents relating to the so-called Operation Fast and Furious. The committee served the subpoena on October 2011. They filed suit August 2012. They won a series of orders requiring productions of documents, but the first such order did not issue until August of 2014, nearly 3 years. In Committee on the Judiciary versus McGahn, the House Judiciary Committee sought to enforce a subpoena to require White House counsel Don McGahn to give testimony regarding matters relating to the special counsel's investigation. Now, we served that subpoena in April of last year. We filed suit in August of last year. We won a favorable district court order in November of last year. The Court of Appeals has stayed that ruling and didn't hear arguments until early this month, with an opinion and potentially unlikely Supreme Court application likely to follow. We will not have an answer likely this year. Sometimes courts move quickly, but here they haven't, not at all. Even when the House urges expedited action, it usually takes years, not months, to get evidence through judicial proceedings. Now, the President can't put off impeachment for years by ordering total defiance of the House and then insist the court go to court even as he argues that they can't go to court. That's especially true where the President doesn't just raise one or two objections to specific subpoenas, but orders a blanket, government-wide cover-up of all evidence. That kind of order makes this clear. The President sees himself completely immune from any accountability, above the law. It reveals his pretensions, really, to absolute power. It confirms he must be removed from office. Now, here's the key point. President Trump's obstruction of Congress is not merely unprecedented and wrong, it's also a high crime and misdemeanor, as the framers used and understood that phrase, warranting his immediate removal from office. To see why, let's return to first principles. As the framers deliberated in Philadelphia, George Mason posed a profound question. Shall any man be above justice? That question wasn't a hypothetical. The framers had just rebelled against England, where one man, the king, was in fact above justice. By authorizing Congress to remove presidents from egregious misconduct, the framers rejected that model. Unlike Britain's king, the president would answer to Congress and thus to the nation if he engaged in serious wrongdoing, because the impeachment power exists not to punish the president, but to check presidents. It can't function if presidents are free to ignore all congressional investigation and oversight. An impeachment scholar, Frank Bowman, said this: without the power to compel compliance with subpoenas and the concomitant right to impeach a president for refusal to comply, the impeachment power would be nullified. So the consequences of presidential obstruction go beyond any particular impeachment inquiry. They go to the heart of the impeachment power itself. They weaken our shield against a dangerous or corrupt president. Now, of course, presidents are still free to raise privacy, national security, or other concerns in the course of an impeachment inquiry. There's room for good faith negotiations over what evidence will be disclosed. Although there is a strong presumption in favor of full compliance with congressional subpoenas. But when a president abuses his office, abuses his power to completely defy House investigators in impeachment inquiry, when he does that without lawful cause or excuse, he attacks the Constitution itself. When he does that, he confirms that he sees himself as above the law. President Nixon's case is informative. As noted, President Nixon let his senior officials testify. He produced many documents. He did not direct anything like a blanket, indiscriminate block of the House's impeachment inquiry. He still did defy subpoenas seeking records and recordings of the Oval Office. Now, President Nixon claimed that his noncompliance was legally defensible. He invoked the doctrine of executive privilege. The Judiciary Committee rejected that excuse. The committee emphasized that, quote, the doctrine of separation of powers cannot justify the withholding of information from an impeachment inquiry. After all, the very purpose of such an inquiry is to permit the House, acting on behalf of the people, to curb the excesses of another branch, in this instance, the executive. Quote, whatever the limits of legislative power in other contexts, and whatever need may otherwise exist for preserving the confidentiality of presidential conversations in the context of an impeachment proceeding, the balance was struck in favor of the power of inquiry when the impeachment provision was written into the Constitution. Now, ultimately, the committee approved an article against Nixon because he sought to prevent the House from exercising its constitutional duty. Article 3 charged Nixon with abusing his power by interfering with the discharge of the Judiciary Committee's responsibility to investigate fully and completely whether he had committed high crimes and misdemeanors. President Nixon's third article of impeachment explained it this way, quote, in refusing to produce these papers and things, Richard M. Nixon, substituting his judgment as to what materials were necessary for the inquiry, interposed the powers of the presidency against the lawful subpoenas of the House of Representatives, thereby assuming to himself functions and judgments necessary to the exercise of the sole power of impeachment as vested by the Constitution in the House of Representatives. In all of this, Richard M. Nixon acted contrary, in a matter contrary to his trust as president, subversive constitutional government, to the great prejudice of the cause of law and justice, and to the manifest injury of the people of the United States. President Nixon's case powerfully supports the conclusion that presidential defiance of the House impeachment inquiry constitutes high crimes and misdemeanors. You know, I've been thinking a lot about the founders. I've been rereading the Constitution and the notes from the Constitutional Convention. It was just a little over 230 years ago that they met in Philadelphia, not too far from here. They'd been at it for a long time. They didn't know whether the Constitution they were trying to write would sustain freedom, but they were trying to create a completely different type of government. On July 20th, Governor Morris said this, "The magistrate is not the king. The people are the king." George Mason of Virginia on that same day said, "Shall any man be above justice? Above all, that man may be above it who can commit the most extensive injustice." And Eldridge Gerry argued that he hoped that the maxim that the chief magistrate could do no wrong would never be adopted here. Now, finally, on September 8th, they adopted the impeachment clause in the U.S. Constitution. But I hope that we will remember the admonition that we should never accept the fact that the magistrate, the president, can do no wrong. They crafted a Constitution to protect our liberty and the liberty of those who will follow us. Professor Noah Feldman talked about the Constitution in his testimony before the House.
A president who says, as this president did say, "I will not cooperate in any way, shape, or form with your process," robs a coordinate branch of government. He robs the House of Representatives of its basic constitutional power of impeachment.
You know, a president who does that also endangers the American people by stripping away the Constitution's final safeguard against presidents who abuse power and harm the nation. Such a president acts like a king, which the founders were fighting against. That's what they wrote out of the Constitution. A president cannot be immune from oversight, accountability, and even simple justice in the exercise of the powers entrusted to him. We can't let that stand in this case. The president must forfeit the powers that he's abused and be removed from office.
Mr. Chief Justice, distinguished members of the Senate, counsel for the President, my colleagues, the American people who are assembled here today. I think we have our next break scheduled for within the hour, and so I find myself in the unenviable position of being the only thing standing between you and our dinner. But be not discouraged, because I'm going to try to follow the advice of a former Sunday school teacher of mine, grew up in the Cornerstone Baptist Church in Brooklyn. She said, Jeffries, on the question of public presentations, be brief, be bright, and be gone. And so I'm going to try to do my best. Presidents are required to comply with impeachment subpoenas. This president has completely defied them. That conduct alone is a high crime and misdemeanor. The facts here are not really in dispute. President Trump's defense appears to be, I can do whatever I want to do. Only I can fix it. I am the chosen one.
Then I have an Article 2 where I have the right to do whatever I want as president.
Nobody knows the system better than me. Which is why I alone can fix it. Somebody had to do it. I am the chosen one. Somebody had to do it.
Is that who we are as a democracy? President Trump can't address the substance of our case. He therefore complains about process. But these procedural complaints are baseless excuses, and they do not justify his attempts to hide the truth from Congress and from the American people. The president's arguments fail for 4 simple reasons. First, the House, not the president, has the sole power of impeachment and the sole power to determine the rules of its proceedings. That's Article 1, Section 2 of the Constitution. Second, President Trump's due process argument has no basis in law, no basis in fact, no basis in the Constitution. President Trump may not preemptively deny any and all cooperation to the House and then assert that the House's procedures are illegitimate because they lack his cooperation. Third, President Trump's claim that he is being treated differently completely lacks merit. Despite what he contends, the House provided President Trump with greater protection than what was given to both President Nixon and President Clinton. The fact that President Trump failed to take advantage of these procedural protections does not mean they did not exist. President Trump is not the first president to complain about House procedures. He won't be the last. He's not the first one to challenge the motives of any investigation or certainly an impeachment inquiry. Such complaints are standard operating procedure from the Article II executive branch. President Johnson, President Nixon, President Clinton had plenty of complaints. But no president has treated such objections as a basis for withholding evidence, let alone categorically defying every single subpoena. None, except Donald John Trump. Finally, the obligation to comply with an impeachment subpoena is unyielding. It does not dissipate because the president believes House committees should invite different witnesses, give his defenders unfettered subpoena power, or involve his personal lawyers at the deposition stage of the process when that has never been done. And if a president can defy Congress on such fragile grounds, then it is difficult to imagine why any future president would ever comply with an impeachment or investigative subpoena again. Now, throughout our history, impeachments have been rare, and the Supreme Court has made clear that it's wary of intruding on matters of impeachment. This, of course, leaves room for inter-branch negotiation, but it does not allow the president to engage in blanket defiance. President Trump's objections are not genuinely rooted in the law. They are not good faith legal arguments. We know that because President Trump said early on he would fight all subpoenas. We know that because he declared the impeachment inquiry illegitimate before it even adopted any procedures. We know that because he has denounced every single effort to investigate him as a witch hunt. And we know that because he never even claimed executive privilege during the entire impeachment proceeding. President Trump's first excuse for obstructing Congress is his asserted belief that he did nothing wrong, that his July 25th call with President Zelensky was perfect. In the October 8th letter sent by his counsel, President Trump asserted the prerogative to defy all House subpoenas because he has declared his own innocence. As Mr. Cipollone put it, at President Trump's behest, the president did nothing wrong, and there is no basis for an impeachment inquiry. He had the White House counsel include this in a formal letter to the House, defying every single subpoena. As we have shown in our discussion of the first article of impeachment, these claims of innocence are baseless. They lack merit. We have provided overwhelming evidence of President Trump's guilt. The president cannot lawfully obstruct the House impeachment inquiry because he sees no need to be investigated. One of the most sacred principles of justice is that no man should be the judge in his own case. And yet, that is exactly what President Trump has been determined to do. But this is America. He cannot be judge, jury, and executioner. Moreover, the president cannot simply claim innocence and then walk away from a constitutionally mandated process. Even President Nixon did not do that, as we have previously established. Congress has a constitutional responsibility to serve as a check and balance on an out-of-control executive branch. Our responsibility is not to this president, it is to the American people. Blanket presidential defiance would bring a swift halt to all congressional oversight of the executive. That principle would have authorized categorical obstruction in the impeachments of President Johnson, President Nixon, and President Clinton. In each of those cases, the House was controlled by a different party than the presidency. And the president attacked those inquiries as partisan. Yet those presidents did not view their concerns with excessive partisanship as a basis for defying every single subpoena. The purpose of an impeachment inquiry is for the House to collect evidence, to determine on behalf of the American people whether the president may have committed an impeachable offense, because the Constitution vests the House with the sole power of impeachment. A president who serves as the judge of his own innocence is not acting as a president. That's a dictator. That's a despot. That is not democracy. The president also believes, it appears, that his blanket obstruction was justified because the House did not expressly adopt a resolution authorizing an impeachment inquiry or properly delegate such investigative powers to its committees. Now, the full House voted in January, in advance of the inquiry, to adopt rules authorizing committees to conduct investigations, issue subpoenas, gather documents, and hear testimony. Beginning in the spring and summer of 2019, evidence came to light that President Trump and his associates might have been seeking the assistance of another foreign government, Ukraine, to influence the upcoming 2020 election. On September 9th, the House investigating committees announced they were launching a joint investigation. They requested records from the White House and the Department of State. This investigation was consistent with all rules approved by the full House. At the same time, evidence emerged that the president may have attempted to cover up his actions and prevent the transmission of a whistleblower complaint to the Intelligence Committee of the Senate and the House. Given the gravity of these allegations and the immediacy of the threat to the next presidential election, the Speaker of the House, a constitutional officer, explicitly named in Article 1, announced on September 24th that the House would begin a formal impeachment inquiry. There is nothing in the Constitution, nothing in federal law, nothing in Supreme Court jurisprudence that required a formal vote at the time. The president has put forth fake arguments about process because he cannot defend the substance of these allegations. Following the announcement of the impeachment inquiry, the House investigating committees issued additional requests and then subpoenas for documents and testimony. The committees made clear that this information would be collected as part of the House's impeachment inquiry and shared among committees, as well as with the Committee on the Judiciary as appropriate. Then, on October 31st, the full House voted to approve House Resolution 660, which directed the House committees to continue their ongoing investigations as part of the existing inquiry into whether sufficient grounds exist for the House of Representatives to exercise its constitutional power to impeach Donald John Trump. In addition to affirming the ongoing House impeachment inquiry, H.Res. 660 set forth procedures for open hearings in the Intelligence Committee and for additional proceedings in the Judiciary Committee. Every step in this process was fully consistent with the Constitution, the rules of the House, and House precedent. The House's autonomy to structure its own proceedings for an impeachment inquiry is grounded in the Constitution. The President's principal argument to the contrary is that no committee of the House was permitted to investigate any presidential misconduct until the full House acted. As a federal district court recently confirmed, the notion that a full House vote is required to authorize an impeachment inquiry has no textual support in the U.S. Constitution or the governing rules of the House. The investigations into misconduct by Presidents Andrew Johnson, Nixon, and Clinton all began prior to the House's consideration and approval of a resolution authorizing the investigation. Recently, under Republican control, the Judiciary Committee considered the impeachment of the Commissioner of the Internal Revenue Service, following a referral from another committee and absent a full vote of the House for an impeachment inquiry. There is no merit to President Trump's argument that the full House had to vote. The sequence of events in this particular case largely tracked those in the Nixon proceedings. The House Judiciary's proceedings began in October of 1973, when resolutions calling for President Nixon's impeachment were introduced in the House and referred to the Judiciary Committee. Over the next several months, the committee investigated the Watergate break-in and cover-up, among other matters, using its existing investigatory authority. The committee also hired a special counsel and other attorneys to assist in these efforts. Most importantly, all of this occurred before the House approved a resolution directing the Judiciary Committee to investigate whether grounds to impeach Richard Nixon existed. In this instance, the committees began the investigation with their existing powers, authorized by the full House. That course of events is entirely consistent with the Richard Nixon precedent. It is also common sense. After all, before voting to conduct an impeachment inquiry, the House must ascertain the nature and seriousness of the allegations and the scope of the inquiry that may follow thereafter. President Trump's second excuse also fails. Let's now address the President's so-called due process and fairness arguments. The President has phrased some of his complaints in the language of due process. He has complained that the procedures were not fair, even though they reflect prior practice and strike a reasonable balance between presidential involvement on the one hand and the House's obligation to find the truth on the other. Presidents come and presidents go. They have all sharply criticized House procedures, but no president has ever treated those objections as a basis for complete defiance. No president has ever done that. In the context of a House impeachment inquiry, it's fair to say that a president is a suspect who may have committed a high crime or misdemeanor. He cannot tell the detectives investigating the possible constitutional crime what they should do in the context of their investigation. In the President's October 8th letter, Mr. Cipollone complains that he was denied the most basic protections demanded by due process under the Constitution and by fundamental fairness, including the right to cross-examine witnesses, to call witnesses, to receive transcripts of testimony, to have access to evidence, and to have counsel present. It sounds terrible, but it's not accurate. The President appears to have mistaken the initial phases of the impeachment inquiry for a full-blown trial. The trial phase of the impeachment inquiry is taking place right now. Chairman Peter Rodino of the Judiciary Committee once observed, as it relates to the impeachment proceedings against President Nixon, it is not a right but a privilege or a courtesy for the President to participate through counsel. An impeachment inquiry is not a trial. Rather, it entails a collection and evaluation of facts before the trial occurs. In that respect, the House acts like a grand jury or a prosecutor, investigating the evidence to determine whether charges are warranted or not. Federal grand juries and prosecutors do not allow targets of their investigation to coordinate witness testimony. The protections that the President label as due process do not apply here. Because those entitlements that he sought, many of which were actually afforded to him, but those entitlements that he sought would not necessarily be available to any American in a grand jury investigation. Moreover, it should be clear that the House, notwithstanding this framework, has typically provided a level of transparency in impeachment inquiries, particularly as it relates to presidents. In past impeachment inquiries, this has typically meant that the principal evidence relied upon by the House Judiciary Committee is disclosed to the President and to the public, though some evidence in past proceedings has actually remained confidential. The President has typically been given an opportunity to participate in the proceedings at a stage when evidence has been fully gathered and presented to the Judiciary Committee. President Trump was given the chance to do that in this case, but he declined. Presidents have been entitled to present evidence that is relevant to the inquiry and to request that relevant witnesses be called. President Trump was given the chance to do that in the House impeachment inquiry before the Judiciary Committee, but he declined. Under House Resolution 660, President Trump received procedural protections not just equal to, but in some instances greater than that afforded to Presidents Nixon and Clinton. So let's be clear. The privileges described in the October 8th letter were, in fact, offered to President Trump, as they had been in prior impeachment inquiries. The President was able to review all evidence relied on by the House investigating committees, including evidence that the minority's public report identified as favorable to President Trump. During the Judiciary Committee proceedings, the President had opportunities to present evidence, call witnesses, have counsel present to raise objections, cross-examine witnesses, and respond to the evidence raised against them. As the Rules Committee report accompanying House Resolution 660 noted, these privileges are commensurate with the inquiry process followed in the cases of Nixon and Clinton. President Trump simply chose not to avail himself of what had been offered. The fact that President Trump declined to take advantage of these protections does not excuse his blanket unconstitutional obstruction. Unlike the Nixon and Clinton impeachments, in this particular instance, the argument that the President has made, the argument that he has made as it relates to the investigative process is not analogous. In this case, the House conducted a significant portion of the factual investigation itself because no independent prosecutor was appointed to investigate the allegations of wrongdoing against President Trump. Attorney General William Barr refused to authorize a criminal investigation, into the serious allegations of misconduct against the president. They tried to whitewash the whole sordid affair. Left to their own devices, the House investigative committees followed standard best practices for investigations, consistent with the law enforcement investigations into Presidents Nixon and Clinton in advance of their impeachments. The committees released transcripts of all interviews and depositions conducted during the investigation. During the investigation, more than 100 members of the House participated in the so-called closed-door proceedings. More than 100 members of the House, 47 of whom were Republicans. They all had the opportunity to ask questions. They all had the opportunity to ask questions with equal time. The Intelligence Committee held public hearings where 12 of the key witnesses testified, including several requested by the House Republicans. It is important to note that the very same procedures in House Resolution 660 was supported by Acting White House Chief of Staff Mick Mulvaney when he served as a member of the Oversight Committee, and by the Secretary of State Mike Pompeo when he served as a member of the Select Committee on Benghazi.
Tell you in the private interviews, there is never any of what you saw Thursday. It is 1 hour on the Republican side, 1 hour on the Democrat side, which is why you're going to see the next 24 interviews done privately, because it is, I mean, look at the other investigations that are being done right now. The Lois Lerner investigation that was just announced, was that public or private?
If this process was good enough for other presidents, why isn't it good enough for President Trump? Representative Gowdy finished that statement by saying, "The private ones have always produced the best results." The private ones, according to Trey Gowdy, have always produced the best results. President Trump complained that his counsel was not afforded the opportunity to participate during the Intel Committee's proceedings. But neither President Nixon nor President Clinton were permitted to have counsel participate in the initial fact-gathering stages when they were investigated by special counsel, independent counsel. President Nixon certainly had no attorney present when the prosecutors and grand juries began collecting evidence about Watergate and related matters. President Nixon did not have an attorney present in this distinguished body when the Senate Select Committee on Watergate began interviewing witnesses and holding public hearings. Nor did President Clinton have an attorney present when prosecutors from the Office of Independent Counsel Kenneth Starr deposed witnesses and elicited their testimony before a grand jury. President Trump's attorney could have cross-examined the Intel Committee's counsel during his presentation of evidence before the House Judiciary Committee. That would have functioned as the equivalent opportunity afforded to President Clinton to have his counsel cross-examine Kenneth Starr, which he did at length. President Trump was provided a level of transparency and the opportunity to participate consistent with the highest standards of due process and fairness given to other presidents who found themselves in the midst of an impeachment inquiry. The president, and I'm winding down, The President's next procedural complaint is that it was unconstitutional to exclude agency counsel from participating in congressional depositions. The basis for the rule excluding agency counsel is straightforward. It prevents agency officials who are directly implicated in the abuses Congress is investigating from trying to prevent their own employees from coming forward to tell Congress and the American people the truth. It's common sense. The rule protects the rights of witnesses by allowing them to be accompanied in depositions by personal counsel, a right that was afforded to all of the witnesses who appeared in this matter. Agency attorneys have been excluded from congressional depositions of executive branch officials for decades under both Republicans and Democrats, including Republican Chairman Dan Burton, Republican Chairman Darrell Issa, Republican Chairman Jason Chaffetz, Republican Chairman Trey Gowdy, Republican Chairman Kevin Brady, and Republican Chairman Jeb Hensarling, just to name a few. Again, the Constitution provides the House with the sole power of impeachment and the sole authority to determine the rules of its proceedings, which were fair to all involved. Given the Constitution's clarity on this point, the President's argument that he can engage in blanket obstruction is just dead wrong. President Trump also objects that the House minority lacks sufficient subpoena rights. But the subpoena rules that were applied in the Trump impeachment inquiry were put into place by my good friends and colleagues on the other side of the aisle, House Republicans, when they were in the majority. We are playing by the same rules devised by our Republican colleagues. President Nixon did not engage in blanket obstruction. President Clinton did not engage in blanket obstruction. No president of the United States has ever acted this way. Lastly, we should reject President Trump's suggestion that he can conceal all evidence of misconduct based on unspecified confidentiality interests. Those are his exact words, confidentiality interests. But not once in the entire impeachment inquiry did he ever actually invoke executive privilege. Perhaps that's because executive privilege cannot be invoked to conceal evidence of wrongdoing. Perhaps that's because executive privilege does not permit blanket obstruction that includes blocking documents and witnesses from the entire executive branch. Perhaps President Trump didn't invoke executive privilege because it has never been accepted as a sufficient basis for completely and totally defying all impeachment inquiries and subpoenas. Or perhaps President Trump didn't invoke executive privilege because when President Nixon did so, he lost decisively, unanimously, clearly before the Supreme Court. Whatever the explanation, President Trump never invoked executive privilege, so it is not a credible defense to his obstruction of Congress. President Trump has lastly suggested that his obstruction is justified because his top aides are absolutely immune from being compelled to testify before Congress. Every federal court to consider the so-called doctrine of absolute immunity has rejected it. In 2008, a federal court rejected an assertion by the 43rd President of the United States that White House counsel Harriet Miers was immune from being compelled to testify, noting that the president had failed to point to a single judicial opinion to justify that claim. And on November 25th of last year, another federal judge rejected President Trump's claim of absolute immunity for former White House counsel Don McGahn. The court concluded executive branch officials are not absolutely immune from compulsory congressional process, no matter how many times the executive branch has asserted as much over the years, even if the president expressly directs such officials not to comply. The court added, simply stated, the primary takeaway from the past 250 some odd years of recorded American history is that presidents are not kings. The president is not a king. President Trump tried to cheat. He got caught. And then he worked hard to cover it up. He must be held accountable for abusing his power. He must be held accountable for obstructing Congress. He must be held accountable for breaking his promise to the American people.
My foreign policy will always put the interests of the American people and American security above all else. Has to be first. Has to be. That will be the foundation of every single decision that I will make.
What does it mean to put America first? America is a great country, but above all else, I think America is an idea, a precious idea, an idea that has withstood the test of time, an enduring idea. Year after year, decade after decade, century after century, as we continue our long, necessary, and majestic march toward a more perfect union. America is an idea. One person, one vote. Liberty and justice for all. Equal protection under the law. Government of the people, by the people, and for the people. The preeminence of the rule of law. America is an idea. We can either defend that idea or we can abandon it. God help us all if we choose to abandon it.
Majority Leader is recognized.
Mr. Chief Justice, we'll take a 30-minute break for dinner.
Without objection, so ordered.
Do I do this?